again, now we're going to court to try to get this?
If we have a problem, we've had a number of people pass away since the beginning of the year, and we've only got a couple where we think we're going to actually have to go to court to make to make it work right. You know, fortunately, there has been enough. They either haven't used formulas. I've got one we're working on right now where there's formulas. As it turns out, unbeknownst to me, the husband and wife who I did the estate plan for many years ago haven't been living together for the last 20 years.
Oh my gosh!
And so now, and they've kept everything in their co-owned trust. Yes. Even though they've been separated and living in different parts of California, and there are different provisions. And the good news is that it happens to be the husband who survived, and the kids are all of the same mind. So there's not going to be any dispute. Yeah. But you could see where there could be a dispute if somebody said, "Oh no, that formula means what it means, and I want my money now." Yes.
Okay. Well, there are different lifetime planning techniques that we have used that may not work under this new regime. And I was wondering if you could talk about some of those that probably can't really do this year, or may not be able to do.
Well, we've done a lot of CUPRTs. The whole purpose of a CUPRT is to avoid an estate tax.
Now that's a qualified
qualified personal residence trust.
Okay.
Lawyers have a tendency to talk in acronyms. Yeah. It's a qualified personal residence trust, which was a device to allow where you could get a principal residence out of your taxable estate and to your kids. You can still use it, but the problem is there's no estate tax. It doesn't do any good. And so there would be a bit of a gamble doing it this year. Because if you died this year, you wouldn't need it. Yeah. If you're going to continue it on for a number of years, yes, it still might make some sense. Probably the one that we use the most, which is a sophisticated lifetime giving technique, it's called a grantor retained annuity trust. And that is designed over a period of time to transfer appreciation in assets to family members, basically estate and gift tax free. It's very effective in our community if you have people that have stock that's about to go up in value. If you get a pre-IPO stock, or just, well, used to be developing real estate used to be another use, but that's too risky right now. But they still have a use if we have an estate tax, and grants would go over a period of years. They usually go right now a minimum of 2 years. One of the pieces of legislation that's pending would have grants have a minimum 10-year term, which would dampen their effectiveness. But they still can work extremely well, and frankly, we're doing a lot of them as people are anticipating even a worse estate tax next year. So doing one of these grants would make sense now. But that's a sophisticated tool. You've got to use get to an attorney who knows what he's doing.
Yeah, and so, but what it comes down to is that there's many of these things that we have these traditions of using or whatever, and now things are really sort of up in the air. And I guess another one that we're a little concerned about has to do with family partnerships.
Yes. Well, family partnerships, is once again a technique we use to lower value. You can basically, if you take a business entity that's worth, say, $100,000, and you break it up into 10 pieces, each piece isn't worth 10,000. Each 10% piece isn't worth 10 grand. It's probably worth 5 grand. Because the test is what you as an outsider would pay me to buy that interest. Right. And so we go through what's called valuation discounting. One of the things that's been kicked around in Congress is to stop people from doing that. Completely as a question whether it's constitutional or not. But that's another thing, and that people are,
there's a proposal that's floating out there, and we just don't know what's going to happen.
Yeah, that proposal's there. We don't
know.
We're
all over the place.
And it's a transaction that's complex and expensive and has some other risks. So people, I think, are a little hesitant to do it when the tax system is as unsure as it is at the moment.
Okay. What are some things to think about doing now?
Well, if you're planning on making a generation skipping direct transfer, this would be the time to do it, because you can, and under the gift tax rules, you can do $1 million, and it's subject to that. But even if you go over, you're only subject to one tax, and that's the gift tax. Where before, if you went over the $1 million, you would pay not only the gift tax, you'd also pay the generation skipping tax with an effective total rate of about 70%. So if you're considering doing generation skipping gifting, this may be the time to do it. Another interesting concept that I'm working on right now is that right now there is no federal estate tax. So if you have a trust or estate that's pending, you could make complete and outright distribution because there's no requirement to report it, there's no requirement to do anything. And so making distributions rather quickly might be something to think about. I think probably the more prudent thing people are going to do is that even for people dying in January, if they made the tax retroactive, that tax return wouldn't be due until about April of 2011. You can put it on, it's due in 9 months, and you get an automatic 6-month extension. So you could push out the actual requirement date for filing quite a ways. And so prudent, you probably wait, but if you're aggressive, you might just distribute and say,
go for it.
Go for it, there's no tax, I'm distributing, I'm done.
Okay, so fortune favors the brave.
I guess so,
Yeah.
Absolutely.
I guess another question here, though, is as a trustee, you know, are you going to be on the hook if something goes wrong?
You know, I'm researching that right now. We have actually been retained to render an opinion on this exact point, where a trustee of a trust has been approached by the beneficiary saying, we want you to distribute this trust right now, and it would be taxable in 2009. It's not taxable now. And what that trustee's liability is interesting, because I don't have the answer yet, because the trustee has an obligation to the beneficiaries to, you know, manage the trust, and there is no tax. The trust is ready to be distributed already. There's no dispute over anything. And whether the trustee can make tax reserves, seek some kind of indemnification from the beneficiaries, it's up in the air. And it's going to hinge on retroactivity effect too. So,
yeah, it's a very difficult area right now.
Absolutely.
So folks, be careful out there, but be aware. Again, this is mostly going to apply to people who have quite a bit of property.
Correct.
And so that might be a saving grace for some of us. Well, it's time for us to wind this thing up, Jim. I want to thank you so much for being my guest with me on the show today. And we're going to be getting together again, but anyway,
Pleasure, Mike.
Really appreciate it. And folks, thanks again for joining us today, and we'll see you next time on Financial Insider Weekly.